All right. Next part of our lecture is to talk about case briefing. So this part is the Stasky part of the reading, chapters 2 to 5. Um, so first, we want to talk about why we would brief a case. You brief a case to give a summary of a reported case opinion in language that you can understand. Ways that it can help you. It helps you figure out what the court is saying by doing the process of case briefing. Also, say you're doing a larger research project, you keep the case briefs of all the cases that you've read as a way to keep track of research that you've performed. And then you can use those notes later when you're writing your legal brief, your memo, your motion, whatever. And it gives a structure. It's a way to understand what the court's rulings and reasons are. Now, I think maybe it's the next slide. There's different kinds. Legal professionals use the term briefs um, a lot, but there are other kinds of briefs: trial briefs, appellate briefs, briefs in support of a motion, things that we will talk about later on in the semester, but don't confuse them. A case brief is really just your own notes to determine what the meaning of a case is. Okay, so message number one is don't freak out. You read a case for the first time, you're like, what the heck? I do not speak Mandarin. It's a whole different language for me. But don't worry at first. Just you have to take your time to go through it. Judges in their case briefs assume that the people reading these case briefs they're in the court opinions. They assume that the reader has legal knowledge, and as you progress, you will acquire more legal knowledge. But they do give you a lot of the information in the opinion itself. Case analysis isn't something lickety split, boom, 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 which, when I was going over Trump versus Hawaii, as you can even see as I was going through it, I was trying to go boom, 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 but it does take time. And sometimes the judges aren't that great of writers. I'm going to work with you on your sentence structure and things like that later on in the semester, but maybe they're not doing it that way. And, the reason why these cases are on an appellate court level is because it's complicated. If it was easy, it would never get to this point. So you're fine. You're good at this point. We're going one step at a time. Okay. Oh yeah, different kinds of briefs. There you go. So we're working on case briefs. Okay, so on Stasky, they give us a little more to put in a case brief than in the Hamey's outline, but it actually is really the same thing. So we had, right, facts, judicial history, issue, rule analysis, your conclusion. They're just adding the name and the citation. Of course, you need the name and the citation. One thing that I think is helpful when you're writing your case brief, you put your name and citation, do it in Blue Book form. So that way, when you are doing your research, your work product later, you have your Blue Book right there. Or if you need to go back and find it, you have all the information that you need to go and find it right there in your legal brief. Okay. So our judicial history, again, is our procedure, how we got here procedurally. Our facts, that's the story behind the dispute, why the lawsuit was filed in the first place. The issues, those are the legal questions presented to this court. Our rules, those are our laws, the relevant law. What is the court looking to make its decision? Is there case law, statutory law, constitutional law? What law governs here? In Trump, it was like an administrative regulation, all kinds of different rules. The analysis is the most important. It's where the court applies the facts to the relevant laws, and then they make their decision, their holding, or their conclusion. Okay, so this is all on page 41 of Statsky, talking about the components. Just some notes. When you're writing a case brief, remember, you're not like trying to persuade somebody to your opinion at this point. You're just informing, you're giving yourself your own notes. Your audience can be you. If it's just you, it can be informal bullet points, abbreviations, things that you can understand. But I make this mistake especially if I handwrite something, I have something informal or abbreviations, and later on I go back to it and I don't understand what I wrote. So make sure it's something that you will understand now and you will understand in the future when you are reading it. Okay, if you are writing a brief for an assigning attorney, make it professional, right? You're a professional. Use complete sentences, not abbreviations. Use proper citation as is appropriate. All right, so now I think I'm on page 3, our parties. Okay, we have the caption of a case. Okay, in the caption, it lists the parties. So there can be two parties. There was at least two parties. On page 45, you have International Paper Company versus Michael B. McCougan. Okay, so you have two parties. Okay, you see the International Paper Company. It doesn't say plaintiff or defendant here. It says appellant and appellee. Appellant is the party that is filing the appeal. Appellee is the party who is opposed to the appeal, right? Against whom the appeal is being filed. When you have multiple parties on the other part of the page on Stasky, you'll see there's a bunch. Now look, you're only, when you're writing your caption or your name, you're only going to use the first one on each list. So die is the first one, and then of the appellants, and then the city of Phoenix is the first one of the appellees. So that would be die versus city of Phoenix. Now it has it in all caps here just to differentiate which are the named parties and which are the other parties. In your Blue Book citation, you're going to do that in regular case. So capital I, lowercase n for international. You're not going to do it all caps. So don't put in at all, don't put in etc. Only just the first party in the list. In re, so sometimes say you have an estate, or sometimes it's a child custody case. So you would just put that would be in re, and then whoever the party is, in re, Marco, state of Marco, or something like that. So you can usually figure it out from the case as you see it. Okay, so then those are our names. And then we want to figure out, when we're first reading our case, like, who are these people or entities? Okay, who are they in relationship to each other? Okay, so if you see on page 46 and 47, there's different characterizations. So you can have, are they in a business relationship? Is there an accident? Okay, they were both drivers or passenger. Neighbors, doctor, patient, employer, employee, seller, purchaser. And this isn't necessarily something that you need to put in your brief itself, but you need to figure out, who, as a way of helping you with the facts. So you're like, oh, so this is the guy who got hurt, and this is the guy who was driving the car. What's their relationship? So you might want to figure that out when, as one of the initial parts of your legal brief. So, maybe it's a prosecutor and a criminal defendant. Litigation status. Okay, so, normally in a case, right, when we're filing a lawsuit, we think about plaintiff. Plaintiff one is the one bringing the lawsuit, and the defendant is the one defending against the lawsuit. In an appeal, the person filing the appeal is called the appellant, and the person against whom the appeal is being filed is called the appellee. Appellant, appellee. ANT is the one doing something. Okay, in just a regular motion, you have the person making the motion. That is the movant, moving. I am moving to have this evidence excluded. And the person against that is called the respondent. They're responding to that request. So, be mindful of these words. I think some of these terms might be on the quiz this week, but it's important. Those terms are terms that are going to come up periodically throughout the class, and perhaps in your legal career, especially if you're doing litigation. So it's important to know what they mean. Now, the courts will also use the phrase below versus here. Okay, so if an appellate court is talking about something and they're talking about this case, they might say the court below said, right? So that means if I'm the appellate court, that means the trial court is the court below. And then here means the case that they're actually writing. Okay, so that's the tense of it, right? Even the Supreme Court, in below would be a lower court, okay, versus here, which is the case that they're, the level that they're talking about right now. Oh, we don't even have to do this. These practice assignments are part of our homework, so don't worry about it. Just going to delete that. Okay. So, our party objectives. Okay, so this is part of our facts, right? Our underlying facts. What brought about the lawsuit? What did the plaintiff want? What happened? Okay, so this is part of our facts section. Where do we look to find that? You look through the syllabus. Remember that syllabus section we looked at in Trump versus Hawaii? It's just kind of a summary of what happens in the case. First few paragraphs infer through the facts of the case. And then remember, sometimes the underlying objectives are not what's on appeal. Sometimes what's on appeal is just part of the procedure, how this case proceeded through the court system. Okay, usually the plaintiff is seeking to get something done, something from the defendant, or seeking just to stop the defendant from doing something. The defendant, they don't want to either give the plaintiff what they're asking for, or they deny what they say. Sometimes they are seeking relief of their own. That is called a counterclaim. So that's just something to think about. All right, on to chapter 4, legal theories. Okay, so legal theories are the legal grounds by which a party is hanging his hat. Why? What is he basing his lawsuit on? What are the legal grounds? Emphasis on legal. Okay. Cause of action is the legal basis for suing. You can't sue someone without legal grounds, and legal grounds would constitute a valid cause of action. Why are you allowed to bring this lawsuit? So maybe it's a tort case brought in a negligence theory, or a breach of contract case brought, for violation of a written contract. So your cause of action has to be based in statute, a constitution, or common law. Okay, and when you're filing your initial complaint, each cause of action will have requirements, or we also call them elements. So your complaint has to satisfactorily allege this valid cause of action. It must have to have all those elements and the facts that satisfy those elements in the complaint. Otherwise, the complaint can be dismissed for failure to state a cause of action. Okay. So, reasons why, your complaint might fail. If the defendant, they would deny the facts, that the facts are true. They may have a counterclaim that there was contributory negligence, there was no causation, or maybe they claim that, these are theories of the defense, that the cause of action is unconstitutional on itself. All right. So that's our legal theories. Then maybe we talk about litigation history. Sometimes I call it procedural posture, procedure. How did we get here? It's not really how we got to the courthouse in the first place, but what happened in the courthouse, what was this legal mistake that made it go up on appeal. Okay, it helps you understand the purpose of the opinion. So if I'm maybe reading a case deciding, a summary judgment motion was wrongfully granted. So maybe the underlying facts aren't so important. Maybe it's the procedure. What rules of procedure were followed or not followed, or what standard was not met. And so because anything that you've seen, these case opinions, especially 100% in Illinois, they are appellate decisions. So they're looking at lower court procedure. You have these like federal decisions that you will read, like in the federal supplement or the bankruptcy court reporter, and there might be no prior proceeding history. Other kinds of prior proceedings are all sorts. So usually it's the trial court, but sometimes there's an administrative hearing. So if I go to the employment um, Equal Employment Opportunity Commission and I have a hearing, I can appeal that to, say, a trial court, a federal trial court, and then then maybe I can appeal to an appellate court. So that is a type of prior proceeding, an administrative proceeding. Usually, again, it's a trial court. An appeal can only be made after a decision is made by the trial court. They've entered an order. Usually, it's after the final judgment, right? The jury comes back with their decision, and then the court puts out a final judgment. And then it goes to appeal. But so after the final judgment, the parties can look back throughout the case for issues that have been preserved, right? They objected verbally, or they wrote a motion or something like that. So it has been preserved. But sometimes before the final judgment, there is something called an interlocutory appeal. And when we go over the Peterson case later on in this module, we'll talk about an interlocutory appeal. So there was an order, one decision made by the court. In the Peterson case, it was about the inclusion of evidence or the exclusion of evidence. And the court, and then the party's like, I have to stop here and move on, otherwise my case is doomed. And so the underlying action is put on pause, it's stopped, and the appellate court is what's going on then. So that's called and then after the appellate court makes the decision, it goes back to the trial court and they proceed based upon the legal decision of the appellate court. Okay, so that's called an interlocutory appeal in the middle. And then the main case it doesn't go on its merry way. It's on pause. They call it stay pending appeal until this decision is made. Sometimes your prior proceeding is even appellate court. If you're in the Illinois Supreme Court or the U.S. Supreme Court, your prior proceeding may be a lower appellate court. And then if you say you're appealing a state Supreme Court decision on a federal issue, it's actually appealable to the U.S. Supreme Court. Let me change that. U.S. Supreme Court. Okay. So all of those can be prior proceedings. Okay, so on page 65 of Hamey's, there's a whole, is it page 65, triplet? Oh, here it is. This was something about a workers' compensation case. Okay, so this guy sought a hearing before the workers' comp board for benefits, and he was denied. So then he appealed that. Okay, so this is an administrative decision. He appealed it to the workers' comp appeal board, and they reversed. So now he has benefits, and he's happy. So then the workers' comp board people appealed to the Michigan Court of Appeals, who denied leave to appeal, and then they appealed again to the Michigan Supreme Court, who accepted it. So it's kind of like there's a lot of proceedings in there. So you have a bunch. So sometimes it gets technical, and you might even have to do a little chart or a listing to help you through these prior proceedings. some terms that are going to be helpful for you: trial brief, case brief, issue reporter. Yeah, we kind of went through all of those things. So your homework is going to be based on this stuff and the cases that we talked about here, pulling from cases that are in the back of Statsky and pulling out things like the parties and their litigation status and their theories and objectives and things like that to as a foundation for case briefing. Okay, so that's it for this part, and I will chat with you when we do our Peterson brief.